Hello, my name is John P.L.C. Today is April 20th, 2016. It's Wednesday, and I'm speaking to you from my West Palm Beach probate litigation law firm in downtown West Palm Beach, Florida. Our firm, the P.L.C. Law Firm, handles probate and business litigation and appeals and disputes involving wills, trusts, estates, guardianships, and related issues of real estate, contracts, bank accounts, and life insurance. I'm going to be speaking to you today about a probate litigation topic, and that litigation topic involves when there are inconsistent or contradictory statements that are alleged in a petition or a complaint and what to do with them. Our probate litigation firm in West Palm Beach has a vigorous defense practice. Although we represent many petitioners or plaintiffs, such as heirs or beneficiaries who have been disinherited, the lawyers at our probate litigation law firm also handle the defense of fiduciaries like trustees, attorneys in fact, powers of attorney, and executors or personal representatives, as well as heirs and beneficiaries who may be involved in a will contest and their inheritance may be at stake. So I'm going to speak to you now about what do you do if you're defending a petition or a complaint that has internal contradictory allegations or statements. In perhaps the most common example that Florida probate lawyers might use is when there's a petition in the probate court, perhaps to overturn a will. And the person who wants to overturn the will is also saying that they were nominated in that will to administer the estate or be personal representative, and because of that, they should have preference in the appointment as the personal representative. Or when you try to overturn a trust, and you say a trust is invalid, and then you file a complaint or a lawsuit or have a count in your complaint that suggests the trust is actually valid. What do you do about that when you have contradictory statements? And I want to give you two issues, legal issues to deal with. One is the election of remedies. The election of remedies is a doctrine that you can understand a little bit more by reading a case called Bueno v. Workman, B-U-E-N-O, B as in boy, v. Workman. The site is 20 Southern 3rd, 993. It's a 2009 case from Florida's 4th District Court of Appeal. Probate lawyers in Florida know the 4th DCA because not only is the 4th DCA the appeals court for Broward, Palm Beach, and Martin counties, three counties that, as far as Florida goes, very populated, but it has its very fair share of probate and guardianship and trust appeals, perhaps busier than the other district courts throughout Florida. So you can look at that case and you can look to see what the court discusses about the election of remedies. The election of remedies in Florida forces a party prior to trial to pick what legal avenue they're traveling under. And so its intent is to prevent double recoveries for the same wrong. Under Florida law, the election of remedies doctrine applies only where remedies in question are coexistent and inconsistent. The remedies are inconsistent. That is, if the allegations of facts necessary to support one remedy are substantially inconsistent with those necessary to support the other, then the adoption of one remedy waives the right to the other. You can't talk out of both sides of your mouth. You can't say in count one the light was green, and then you can't say in count two the light was red, right? That's probably the most simple way to describe the election of remedies. Now, this is a different concept than judicial estoppel. In the election of remedies, we're looking at a complaint, or we're looking at some pleading, and we're looking at inconsistent and contrary positions. Different than judicial estoppel. Judicial estoppel is when you're involved in a present probate lawsuit or estate lawsuit, and there was a prior one, some prior lawsuit involving one of the parties, and there was adjudication. There was a judgment or an order or something. You can't take an inconsistent position in this present trust lawsuit or guardianship lawsuit in Florida that's different or inconsistent from one that was already adjudicated. We're not talking about judicial estoppel here. We're talking about election of remedies and one other concept about inconsistent positions within one pleading. So, for example, in the HCA Health Services of Florida case, 63 Southern 3rd, 935. It's a 4th DCA case from 2011. You can't, in one instance, allege, for example, that a contract is invalid, and if that contract, for example, has an attorney's fee provision, then in the next breath, seek attorney's fees pursuant to that contract provision. If you're saying the contract's invalid, then you can't avail yourself to the attorney's fee provision or any provision of that contract. You're talking out of both sides of your mouth. That's inconsistent, and that could serve to make a mockery of the court. The sky is blue. No, the sky isn't blue. Well, the sky is blue for this one. You can't do that. So in another set of facts, what I want to talk about now is very closely related to the election of remedies, but is a general principle that in order to aid justice and to avoid a mockery of our judicial process and our civil procedure, you can't take inconsistent positions, okay? And it's up to the court to recognize this and to rectify it. So an easy example would be if you're claiming something is one thing, but it's really another, you can't just call it something if the facts that are alleged say it's something else. So, for example, in Shands Teaching Hospital and Clinics, SHANDS, versus the estate of Lawson, 175 Southern 3rd, 327. This is a 1st District case from 2015, August 28, 2015. If a complaint alleges pure negligence or ordinary negligence, but then you have facts and allegations that suggests, no, it's medical negligence, which raises a whole number of other issues, including burdens and pre-suit requirements. If that's the case, then you can't say something is that which it is not, right? If the allegations suggest that it's really medical negligence, you can't argue that it's ordinary negligence, and if, for example, you didn't comply with the pre-suit requirements, a motion to dismiss may be appropriate, or another motion dispositive of the complaint. So, although courts must liberally construe the allegations and often take them in favor of the plaintiff when a motion to dismiss is presented, it's very important to note that there is no obligation to accept internally inconsistent factual claims, conclusory allegations, unwarranted deductions, or mere legal conclusions made by a party, right? If it's a bear, you've got to say it's a bear. You can't call it a pig or a dog or a cat. If you, in another breath or in another allegation, clearly demonstrate that it's a bear, a motion to dismiss may be appropriate. Another case, the Peacock case versus General Motors Acceptance Corporation, a 1983 case, 432nd Southern 2nd, 142, the 1st District of Florida. Contradictory allegations within a single count can neutralize each other and render the count insufficient on its face. So if you have one count and you've got different allegations, that may render that entire count moot. That's different than the election of remedies, which is outside one individual count and speaks to a number of counts. Do you want rescission of a document? Or do you want that document to be valid because you're going to seek certain rights, or you're going to enforce certain rights because that document is valid and you don't want it rescinded? Very important. So another example might be the Brocato case, BROCATO versus Health Options, a 2002 case from Florida's 2nd District Court of Appeal, 811 Southern 2nd, 827. Probate lawyers in Florida don't know these cases. Probate litigators who handle estate lawsuits, will contests, objecting to probate in Florida may and should know these cases for these principles. So in the Brocato case, Look, if you're a planned participant, you may have certain rights. If you're not a planned participant, maybe you have other causes of action that can aid the plaintiff. But you can't say you're a planned participant in one count and then say you're not a planned participant in another count. You need consistent allegations, and you have to elect your remedies. To do otherwise would be to make a mockery of our judicial process and our civil procedure. This concludes my comments about the election of remedies and inconsistent statements within a probate or an estate lawsuit and complaint.